Hello, everyone, and thanks for joining us. I'm Will Kishman of Counsel at Squire Patton Boggs. I'm here with Carmen Cole, a partner at the firm from our Los Angeles office. We're here today to discuss some recent legal updates in the labor and employment space for hospitals, other health systems, healthcare providers, pharmacies, and other organizations that are in the healthcare space. We have a full agenda today. We're going to start with an update from Carmen on some health and safety updates, as well as the status of the proposed nurse staff requirement rule. I'll be taking over after that, and I'll be discussing some labor union related updates, including some key changes in federal labor law, as well as some key changes in the landscape of unionizing in healthcare, especially some notable developments with respect to doctors' unions, medical residents unionizing, and some other new union breakthroughs in organizing. Carmen will be talking about what healthcare employers can do to continue supporting diversity, equity, and inclusion after the SFFA versus Harvard decision and after some higher profile claims or assertions that have been made following that case. I'll be talking about what healthcare employers can do to respond to recent changes in the law concerning non-compete agreements and other agreements that are designed to protect against unfair competition, including what you can do to prepare for the proposed FTC rule that's forthcoming, as well as how to address some recent changes in other federal agencies' enforcement and in terms of state rules and procedures. I'll be discussing a quick anti-kickback case that's relevant for your continued anti-kickback statute compliance, as well as some developments in leave and disability accommodation cases that have arisen in the healthcare industry. And then finally, Carmen will be talking about how healthcare employers can manage remote work requests and obligations while also balancing any efforts to return to work and have certain people shift their approach in terms of working live when that's necessary or prerogative. We hope to have time for questions at the end. If you do have any questions during the course of the session, please add them to the chat and we'll address them during any remaining time. If we don't have time left over, we'll do our best to circle back with you after the presentation. And with that, I'll turn it over to Carmen to discuss health and safety updates.
Thanks, Will, for the great introduction and the overview of what we're going to hit today. It's a lot, folks, so hang on and get ready for a lot of information crammed into a very short period of time. So let's start with a CMS staffing mandate that has recently gone into, or actually was recently proposed. In fact, on September 1st, the CMS issued a proposed rule that requires long-term care facilities, really any long-term care facility that receives Medicare or Medicaid funds, which I think, as we all know here, is basically all of them, to have certain minimum numbers of registered nurses and nurse aides. So, for example, they need to have at least one registered nurse on site full-time, 24/7, 365. They also need to give residents with a minimum number of hours of services per day. So that's in the aggregate across all residents, but they have to have a certain minimum number of hours of service per day from RNs and NAs. So the minimums really will depend on the number of residents at issue, but it's a very costly proposition in terms of staffing and hiring needs. The CMS also proposed, in conjunction with this new proposed rule, that more than $75 million be set aside for scholarships and tuition reimbursements. So this isn't cheap. This proposed rule is something that can have quite devastating impact on healthcare providers or long-term care facilities and their overall budgeting. So it's important to start thinking about it now. There is, as everyone knows, it's no secret, an ongoing nurse staffing crisis that makes this even more troublesome of a rule, frankly. Healthcare employers are already facing so many challenges in this area, most of which I don't even need to talk with you about. But one study showed that as of today, 75% of long-term care facilities don't satisfy the minimum requirements that are proposed by this rule. So if we started this proposed rule today, 75% of long-term care facilities wouldn't make it. And what's worse is that that number of available RNs and NAs is actually projected to shrink by 17,000 over the next 10 years. So the proposed rule is actually, from some perspectives, making a bad problem worse or more difficult to overcome. Another piece of interesting data point is that over 500 nursing homes in the US have closed since COVID began in 2020. So we're on this sort of decline of available RNs and nurses aides, while the CMS proposed rule is actually requiring long-term care facilities to increase them at a time when we're doing just the opposite, we're losing them. So it's no surprise then that there has been a significant amount of industry pushback in this area. The American Healthcare Association says that this rule would require entities in the US to hire about 100,000 additional nurses and nurses aides at a cost of over $6.8 billion a year. That's billion with a B. So the issue is this proposed rule is requiring us to have all of this staffing, but where are we going to get it? Where are we going to find 100,000 additional nurses and nurses aides? And where are we going to find the $6.8 billion to pay them? So the pushback is focused in large part as well, not just that piece of the proposed rule, but the tuition and scholarship component of the proposed rule. One industry group asserts that the current levels would help fund only about 10% of the additional RNs and NAs required by the proposed rule. So it's great, tuition reimbursement is all well and good in theory, but practically speaking, it's only, even on its best day, gonna, satisfy 10% of the problem. So there's been quite a lot of discussion on other ways to offset the new financial obligations, and one of them is likely by increasing Medicare and Medicaid reimbursement rates, right? So the two things should go hand in hand. If you're going to have this proposed rule, then the Medicare and Medicaid reimbursement rate should increase to accommodate what's being asked of these long-term care facilities. There's also some other regulatory developments that concern nurses that we should touch on today. There's been increased enforcement of several other rules around staffing and availability. So for example, in 2022, there were over 1,000 instances where healthcare facilities received citations for failing to satisfy other rules that apply in this area. So if you are one of those facilities, you're one such facility that was dinged for it, you are not alone. There is an uptick and a trend in that area, which is actually, again, made worse by states like mine. In California, where I live, we recently enacted a law in September that creates a unique minimum wage for certain nurses of $25 per hour. And that's something that I know there are some of you on this webinar who I've talked about ways to absorb this cost or ways to manage this cost, particularly since in California, there are even other ordinances or local ordinances that make this general rule of the $25 an hour minimum wage even more cumbersome. So please reach out if you're having questions about how to monitor or how to deal with that, or actually how to be able to achieve compliance with such a rule. We're happy to advise and help on that. But here are some other options for employers to just deal with the burden of some of these staffing requirements and the CMS proposed rule. And something to kind of keep your head up about. The sky hasn't completely fallen yet, but the comment period may have closed for this rule, but the rule hasn't been finalized yet. So there's still some room to work with industry groups or lobbyists and political representatives to try to influence the final rule. In fact, we have lobbyists within our firm who can actually help you do that. So please reach out if you have any interest. But also, I would encourage healthcare employers to think about assessing your options for nurse aides, right? Which might be a more practicable solution than just hiring more nurses. Because one of the interesting things about the rule is that it allows roughly a 5-to-1 ratio of nurse aides to registered nurses. So the answer isn't necessarily we have to run out and hire all of these nurses that, by the way, don't exist at a huge cost. But think about ways to leverage bringing on more nurses aides to meet the compliance requirements of the rule. I'd also suggest making sure that your financial planning leaves some wiggle room or leaves enough resources to satisfy the rule if it does become effective. I would not encourage you to just kind of wait and sit on your hands to see if the rule becomes final before you start planning for it. I think putting some resources aside now and having extra later if the rule doesn't become effective or the rule doesn't become final is better than waiting until the last minute. So start thinking about it now as if it were effective. And definitely keep an eye on that tuition reimbursement piece, and think about identifying early or as early as possible any employees who think you might be good candidates who are going to stay the course and who are going to stick around. Obviously, turnover is high in this area. But if there are candidates you can think of who might be good candidates for the tuition reimbursement and scholarship piece, again, start thinking about that now. So moving on to some other health and safety developments that we want to make you aware of. The first is that the healthcare worker anti-violence laws. Now, there are a number of jurisdictions, California, where I live being one of them, that already have some pretty robust anti-violence and workplace violence laws in place, but they're being even more bolstered and even more detailed as of late. So by July 2024, which I know seems like a little bit of time, but it's not, employers in California will need to comply with the state's new workplace violation protection law that requires employers, among other things, to prepare and implement a workplace violence protection plan. So it's not enough to just have in your handbook, don't hit your coworkers, don't beat them. They're asking for something a little bit more robust, which is an actual plan, a step-by-step protocol of how to monitor and address workplace violence. Cal-OSHA, our California component of OSHA, or agency for OSHA, has had a rule in place for a while, since about 2017, that requires them to have workplace violence plans in place. But the agency is preparing a new rule that will likely set forth a model template sometime in 2024, so that employers are not kind of out there in the dark. Once they issue that template, you can take it and sort of modify it to suit your particular workplace and also comply with what they're asking you to do. So look for that sometime in 2024. OSHA and state agencies have pretty much stepped up the enforcement of various duties and situations that led to workplace violence, right? There's a lot of focus and attention on this area. They've issued citations recently in several situations that involved workplace violence where things might have been a matter of a supervisor or an employer handling a workplace violence situation internally. But these days, OSHA and other agencies are starting to take note of it. So it's not only just an internal employer issue, it becomes an event that could lead to a citation from our government agencies. And in those situations, the citations concern, for example, failing to screen applicants in certain safety sensitive positions, failing to have procedures for responding to situations involving workplace violence, failing to have a protocol in place for what happens if someone brings a gun to work, things like that are more specific, where they are actually citing employers for failing to do these things. In a recent Florida case, after a patient attacked a nurse at a rehab facility, I hope none of you on this call have ever experienced that. But that happened in Florida, and once it did, OSHA issued a 5-figure citation to the facility. The facility was cited for allegedly failing to provide a workplace free from recognized safety and health hazards, including patients' physical assaults, which seems really difficult because, you know, we can't control what patients do, but what we can control is our protocol for how we respond and what we do to prevent those things from happening in the first place. And that's what the agencies are really looking for. In terms of agency enforcement developments, generally OSHA and state agency investigations have declined since the peak of the pandemic. So OSHA inspections of healthcare facilities are down about 84% in 2023 as compared to 2022. That's good, but it can change pretty quick if COVID-19 infection rates increase, which they're cyclical. You know, sometimes they're up and down. So I wouldn't get too excited about them continuing to decline, especially as we head into cold and flu season. I want to hit quickly some COVID-related items because courts are starting to rule on a number of types of claims that were brought up by employees for health and safety issues during the pandemic. Enough time now has passed where these types of claims are making their way through the court system, and we're starting to see some some cases and some law being made around these subjects. One notable case arose where a hospital actually discharged a nurse for missing work during the pandemic, even though she was not eligible for any additional leave for the absences. The nurse claimed that the discharge violated public policy, as reflected in OSHA's general mandate requiring safe work environments. The U.S. District Court for the Central District of Illinois agreed and allowed her to amend her complaint to bring the claim. So what this tells us, and what this has us keep in mind, is that even if an employment decision does not expressly violate any applicable statute, employers should still proceed with caution if the decision arguably could jeopardize health and safety considerations. There's a lot more flexibility in this area than I think there previously had been. There's also been some notable decisions regarding COVID-19 vaccine accommodations, which we're going to discuss later in this presentation. Lastly, I want to quickly hit strikes, sick outs, and other work stoppages. We're going to discuss this a little bit more in a minute, but there have been some major increases in strikes, sick outs, and other work stoppages. Employees and unions frequently have cited health and safety issues. There's been a lot of that, particularly in my state in California with the SAG-AFTRA, the actors strike, and other industries, of course. But health and safety issues are key motivating factors that we're noticing in strikes and sick outs and work stoppages lately. The key concerns typically have been with staffing levels and having proper equipment, crazy, wild work schedules that have jeopardized their ability to meet obligations, including making doctor's appointments and other wellness obligations. So keep an eye on that, and we're here to give you some more advice around how to deal with that later in this presentation. I'm going to hand it over to Will on that segue with union activity, since he is our resident sage on all things union. So Will, take it away.
All right, well, thank you, Carmen. It has been a dramatically new landscape in terms of labor union activity. That's across the country, but it is especially true in the healthcare space. Generally, there have been a lot of trends that have been going in unions' favor. Public opinion in favor of labor unions has increased dramatically over the last 2 years, especially since the start of the COVID pandemic. There have been large increases in the numbers of elections, in unions' rates at winning those elections, in the numbers of unfair labor practice charges. I'm sure that everyone is aware of the fact that 2023 was a banner year in terms of the frequency and also the prominence of strikes. And in healthcare, it wasn't simply limited to the Kaiser strikes. There were more strikes in hospitals and health systems in 2023 than there had been at any point in time over the last 15 years. And that's the same is true in terms of the number of striking employees in the healthcare space. In terms of employees deciding to form and join unions, unions have had some major breakthroughs. You're probably aware that doctors have started unionizing at a very significant rate. There, one very notable example was a Minnesota health system had approximately 400 doctors in a single election vote to unionize, and they formed a bargaining unit that it's very interesting. It also includes registered nurses and physicians assistants. So now they're all on the same side in terms of collective bargaining, and that's going to create for that health system some very interesting and potentially perilous dynamics in terms of, how do we make sure that all these groups that have some different interests are satisfied? That's just one of the ways that this can potentially create significant new issues and new obligations and burdens for health systems. In total, there are now over 100 different healthcare facilities, hospitals, clinics, other facilities providing healthcare that have doctors who have unionized. Now, granted, some bargaining units cover multiple facilities, so it's not like there have been 100 different bargaining units, but this is extended now beyond just a couple offhand or isolated examples. And there also are some very large bargaining units that include doctors. There are multiple now that include over 100 doctors in a single group. So you can imagine the implications if you're a health system and you have over 100 of your doctors who all have the potential to strike or engage in other work stoppages if they are not satisfied with the union contract they receive or with what they receive in collective bargaining. At the same time, the law has changed in some key ways that are emboldening unions, that are making it easier for unions to organize new workers. The most significant change, but by far not the only one, is a new rule which was created by the relevant federal agency in August. It was created by the National Labor Relations Board, which administers most union-related laws in the United States. Under this new rule, so historically, when a union sought to organize a group of workers, and once it had obtained signed authorizations from enough group of those workers, the union would ask the National Labor Relations Board, the relevant federal agency, to hold and administer an election, a secret ballot election, which in this country, if people have to vote on something that's so significant to them in their careers, employers prefer that it be done through a secret ballot. But this new rule basically takes that historical approach and turns it on its head. Under this new rule, if a union gets signed authorizations from enough employees in a particular group, and the union approaches an employer, including any supervisor at that employer, even the most frontline supervisor, and the union requests recognition or employees request recognition of a union, then that's just the burden to the employer to request an election. And if the employer does not request an election within 2 weeks, that's according to the board, a hard and fast deadline, then the employer automatically has to recognize the union without the employees ever getting to vote in the secret ballot election. There's also a new, it's a different new rule, but it's related, that will cause the board to issue bargaining orders far more often than it had in the past. A bargaining order is an order by the National Labor Relations Board that requires an employer to automatically recognize a union as the representative of a group of workers without those workers ever getting to vote in a secret ballot election. And now the default approach will be if an employer commits even a technical violation of the National Labor Relations Act in the period before a union election. So after a union makes a request for recognition, or, in rare cases, even before that, that one single violation, even something as relatively small as having a policy that's facially neutral but overbroad, that can at default cause the board to issue a bargaining order, and in another way require you to recognize a union without people ever getting a chance to vote in an election. There have been some other very big changes as well. The NLRB recently issued new election rules, which greatly speed up the time that if an election is scheduled, that the election occurs after a union makes a request for recognition. So now an election can occur as quickly as 3 weeks after a request for recognition is made, which, as most of you probably know, given that unions typically campaign in the background, they would rather not involve an employer, provide formal notice to an employer that they're seeking to organize a group of workers. So once you learn that a union organizing campaign has been occurring and the union has potentially been speaking with your employees for months, if not longer, you can have as little as 3 weeks to make sure that your people understand the implications of that very important decision about whether to unionize, and make sure they understand all the pros and the cons. There is another new rule that gives unions more flexibility to organize, we call them sometimes cookie cutter bargaining units or micro units or gerrymandered units. They, in short, have far more flexibility to pick and choose who gets to vote or who gets to have a say in whether a group of workers organize. They don't have to organize a single facility or a single shift, a single department necessarily. They think that organizing a smaller group will help them get the foot in the door. They have a lot more leverage to do that now. You may have seen that the NLRB issued a new standard for determining whether an organization will constitute a joint employer of a worker when it uses services from another organization's workers or from third parties, or when it otherwise benefits from those outside workers' services. So this is especially important for healthcare providers that are using, for example, custodial services, temporary labor. Maybe you have an outside medical provider who provides x-ray services or anesthesiology services, things of that nature. Under this new standard, it's much more likely that an organization is deemed to be the employer of the workers who are providing those outside services. And we could spend an entire hour talking about the implications of that rule, but the two key implications are, number one, if you are deemed a joint employer of this other group's workers, then all of a sudden you have all the obligations that an employer has under the National Labor Relations Act, including needing to comply with some of these cumbersome and complex, a little bit archaic rules about what you can and can't say about unions. Rules we'll talk about in a second about what types of policies you can maintain. And then it also can give unions new paths to organizing groups of employees. For example, if there's a group of the third party's employees who have dealings with your own employees, then in some cases, those two groups of people might be able to aggregate together and unionize together in a way that might get them over the hurdle before, whereas they otherwise couldn't have. And then another critical change is the board has a new standard now for when a facially neutral handbook provision or floating policy is deemed to unlawfully chill employees from engaging in union activities or other protected concerted activities, basically efforts to improve working conditions for more than just one person. So this will significantly expand the circumstances where a broad range of different types of policies constitute violations of federal labor law. It's especially prudent to look at policies that address things like confidentiality, which in most cases are now unlawful according to the NLRB for non-supervisory employees. Policies that address personnel conduct, require things like respectful behavior, professional behavior, policies that talk about recording in the workplace, taking videos or photos in the workplace, using an employer's email systems, intranet, other electronic systems. So we really recommend that in any case, especially for employers who don't have unions right now, that you review your handbooks and any floating policies that apply to non-supervisory people to assess whether they create issues under this new NLRB standard. And in some cases, you might need to make an informed decision about, what do we do if this new NLRB standard would require us to have policies that are not sufficient from an operational perspective. But you want to make sure you can make an informed decision on that front and you understand the implications. Now's a really important time to train your supervisors to understand what their obligations are if they see union organizing activities in the workplace. If someone asks them a question about organizing, make sure they understand some of these counterintuitive rules about, for example, no creating the impression of spying, no creating the impression that you're questioning people about their union support, and consider whether now's a good time to provide lawful information to your employees about the implications of unionizing, because again, under these new rules, there could be a situation where people are asked to make a choice and are required to make a choice before they've been fully informed and where they've only heard one side of the story. I'll turn it back over to Carmen now, who's going to talk about ways that healthcare employers can support DE&I in light of some recent trends.
Thanks, Will, and thanks for that helpful info around unions, which is still, I think, for a lot of us, sometimes an area that we're just so unfamiliar with. So thank you for making some sense of that for us. Switching gears to DEI and supporting it in every industry, but particularly in the healthcare industry, is I think of utmost importance, I think, to all of us. And in recent years, employers in the healthcare space and otherwise have recognized the benefits to promoting DEI in their employment practices. I think especially within the last 3 years, I think it's become even more prevalent in all industries and workplaces. I don't need to belabor or tell anybody on this call about all of the benefits that there are to promoting a diverse and workplace and in promoting DEI in your workplace. I think we all already know that. I think what I want to spend some time talking about are some of the pendulum, seeing the pendulum sort of swing the opposite way. So on the one hand, we have lots of support for promoting DEI, but then the pendulum has now swung to where there have been some attacks on employers in all industries, but the healthcare industry is no exception, attacks on attempts to promote diversity. So those are the things I want to talk about and how you as employers can continue with your efforts to promote diversity, at the same time sort of dodge or work your way around some of these attacks on that practice. So as many of you, I'm sure everybody actually on this call is aware that the Supreme Court had a ruling on June 29th. They issued this very high profile ruling in SFFA versus Harvard. And in that case, the court held that, at least in the context of college admissions, that Title VI of the Civil Rights Act and the Equal Protection Clause of the 14th Amendment prohibit certain race-conscious admissions processes. Okay, what the court did not do in that case is rule on any employment practices by private employers. So there was lots of brouhaha around this decision in the context of college admissions, but I think there has been since then some question about how that decision would extrapolate into other areas like ours. The majority opinion actually speaks to this and includes a direct quote in the opinion that says, "Nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise." So in the college admission context, the court is saying, look, you can consider it as a factor, how somebody's race might have affected his or her life. And they were very quick, very clear to sort of carve that out. But what they didn't do is give any guidance on how this is going to affect us in the private sector, if it does at all. I think it does. More on that in a minute. But here's basically the status of the law. After that decision came down, the SFFA Harvard decision basically it emboldened a small but pretty vocal group of special interests and politicians to begin challenging employer programs designed to promote diversity, equity, and inclusion. They said, well, if the court upheld this ruling in the context of college admissions, let's see if we can get that same traction in the private employment space. And a handful of groups that were sort of backed by prominent politicians and donors sent these demand letters to prominent employers in a wide range of industries, healthcare being no exception. And I'm sorry if any of you on this call received such a demand letter. But the demand letters basically say, look, you have a DEI program and it violates the law. You are essentially using a DEI program to effectively discriminate against non-diverse people. So these small groups have sent these demand letters, but it's also happening with state attorney generals. State attorney generals have actually, some states attorney generals have done the same thing. The targets of these demand letters usually include sort of high profile employers. Some high profile prominent healthcare systems receive letters. So it's just safe for you to assume that if you have a diversity, equity, and inclusion program or initiative to promote DEI, that you're going to be on the radar. You could receive a letter like this at any time because it's just a trend that we're seeing. The claims that they're alleging in these demand letters are focused primarily around DEI programs that use quotas or effective quotas. They're focusing on programs that say we need to have X number of diverse candidates, or we need to interview this number of focus on hard and fast sort of numbers, number requirements and quotas. And that's the thing that I think really got lost in the headlines. I think that the approach that we've heard is that they're attacking diversity, equity, inclusion altogether. And in some ways they are, but I think that what they really were focusing on was this notion of quotas. So there has to be a certain number met, and that is the unlawful piece. But what's interesting is that these groups really have a lot of bark and not a lot of bite because they haven't largely followed through on bringing legal action. So if you are one such healthcare employer who received a nasty gram letter about your DEI program from one of these small interest groups, you might have noticed that no lawsuit was ever filed. In fact, there have been no recent court decisions, at least that we're aware of, and we've scrubbed and tried to find them, but there have been no recent court decisions that significantly changed an employer's legal obligations in this area. Okay, so it's a lot of bringing it to your attention, a lot of smoke, but no fire in terms of them actually filing these lawsuits. But threatening these claims has had, I think, what the effect that they were looking for, which is to sort of chill efforts to promote diversity, and created sort of this hesitation for some organizations. And there may be future efforts to continue to sort of freeze or chill promoting diversity in the workplace as a result. But what I want you to keep in mind, and we can go to the next slide, Will, is to not be chilled or sort of be in such fear of a lawsuit that you stop all efforts to support DEI. I think that's one of the big concerns, is that employers are saying, well, we have this SFFA case, we've got this demand letter saying that our DEI program is unlawful. What do we do? It's still the right thing to do at the end of the day, given all that we know about the benefits of a diverse workforce. How do we do this without having the SFFA lawyers come after us with pitchforks and torches? Here's how. There's a number of things to do, some of which are listed here. I don't know that we'll have time to go through all of them, but I'll start by saying just outreach to potential candidates and groups that have been underrepresented historically. Nothing's changed there. There's nothing unlawful or there's no legal risk in expanding the areas from which you advise or advertise for jobs and recruit in ways that are going to help you attract and consider more candidates from underrepresented groups. So for example, interviewing at HBCUs or any other college that has a more diverse student body. Targeted advertising for jobs in diverse neighborhoods, or interviewing candidates near where they live rather than making them travel to you will put you in different spaces. That's not always possible, but it's something to consider. Advertising in publications and websites and social media groups that are viewed more regularly by a diverse group of potential candidates. So just changing the environment in which you place yourself for purposes of hiring is a great way to still promote diversity and not run afoul of the law. Pay and promotion equity reviews are another great thing to do, which frankly, in some jurisdictions, they're not just helpful, they're outright required, but they can also help reduce potential legal risks if you are finding in your pay and promotion audits that some groups are being paid there's a delta or there's a disparity in pay equity that can't be explained that needs to be addressed. Those types of equity and pay reviews can sometimes be pretty enlightening. Scary, sometimes what you find out, but enlightening. Self-auditing for employment practices that may unintentionally be having a diverse impact. This is one that I like a lot because everybody wants to do the right thing, right? We want to feel like we're promoting diversity, but a lot of times the things that we're doing are unintentional or unknown to us. So some self-reflection comes into play when, an employer will still tend to grant more favorable raises to employees who specifically ask for them. The open mouth gets fed, right? The squeaky wheel gets the oil. But studies have shown that in certain cases, these types of practices can have a negative impact on older workers, women, and employees in certain racial and ethnic groups as compared to other employees who, there are some cultures where it's just not appropriate to ask for more money. There's some cultures where it's just not appropriate to initiate a conversation around that. So you have unintentionally affected a group who would ordinarily, it's not their culture to really ask for the thing that you're trying to promote. Some other options for supporting DEI is to grant favorable consideration where an employee's or applicant's diversity shows they have certain favorable qualifications. So let's say, for example, even if SFFA did apply to employment decisions, which it didn't, we know it didn't, the court did recognize that a person's diverse characteristics can still be considered to the extent it evidences other favorable qualifications. So sometimes a person's diverse background will illustrate favorable qualifications, such as showing that they might have been able to overcome a significant challenge. Some of you may have heard of the TED Talk or read the book about grit. Sometimes we find that diverse candidates or candidates from underrepresented groups had to overcome something or more difficult circumstances with grit and perseverance that pretends to how well they'll be qualified for a particular job. Something that I think we're all doing, but that we should continue to do, that remains lawful, in fact is required in some situations for like EEO reporting, is to track DEI metrics. That's how you know how you're doing. Employers need to be careful when you're doing this, however, to not to make any data collection appear to be part of a quota system. So if you're collecting this data, make sure you're not doing it in such a way that it looks like you're gathering data to try to meet a particular requirement. Especially if you don't have a true affirmative action program that's been implemented lawfully and vetted by a lawyer, be really careful about how you're tracking those metrics so it doesn't look like you're trying to meet a quota. Training, as always, is helpful. Mentoring, networking, that doesn't change. So there's still a number of ways, and we're sort of running out of time, so I apologize for being so swift about this. But I want to leave you with the fact that we have SFFA versus Harvard. We have that rule. We have some challenges to diversity, equity, and inclusion programs, but I don't want that to affect employers or have employers feel like they need to take their foot off the gas on DEI. There's still a million ways to promote DEI, and we're available to help you implement some of those if you'd like to talk about them offline. So I'll turn it back over to Will to talk about everybody's favorite, non-competes. Yay.
Well, thanks, Carmen. And just to further your point about DE&I, I think there's enough statistical evidence at this point that a tactful and vetted DE&I program benefits everyone. And it's something that can reduce risk and facilitate compliance in almost every one of these areas that we're talking about today. So it's definitely recommended that employers continue to keep a strong focus on that area. And there's still plenty of room to have a program that can support those important efforts. There have been many healthcare employers use non-competes in a variety of ways. They're often entered into with doctors, with administration officials, and with others. And it's understandable that no employer wants to invest a tremendous amount of time and resources to training a person, to helping them acquire new skills, giving them proprietary information, and then have them leave, especially in a way where they take that resource that you've put into them and they basically use it in a way that competes indirectly with you or directly with you. There have been, however, many developments in the non-compete space. This area of employment law has changed maybe more than any other over the last 2 or 3 years. Many of you might be aware that the FTC, the Federal Trade Commission, recently proposed a rule that would categorically ban non-competes in the U.S., except for some very, very narrow exceptions, for example, for certain sales of the business. This rule is not effective yet. They haven't said when they're going to issue any final rule, but there have been some reports from undisclosed sources that have indicated that it's probably going to be forthcoming sometime in the late winter of 2024, early spring of 2024. So continue to look for that. In the meantime, there have been several other new developments. Governments, attorneys general, different agencies, and even private attorneys have increasingly brought challenges to no-poach agreements. So in other words, agreements between two organizations where one or both agree not to hire each other's employees or agree not to solicit each other's employees. And those types of agreements, perhaps more than any other non-compete or restrictive covenant agreement, are very vulnerable to legal challenges. And in a broad number of cases, no-poach agreements are going to violate the law. So it's highly recommended that if you might have a no-poach agreement, or if there might just be a no-poach provision in an agreement that you entered into on another issue, for example, a service agreement, or maybe an agreement as part of a merger or acquisition, that you review those agreements, and unless you have vetted the provision, unless you're confident that it would survive under applicable law, that you take steps to void it or otherwise address it. And it's notable that these no-poach violations often can give rise to criminal liability, including in a lot of cases, criminal liability for an individual, not simply for an organization. The National Labor Relations Board has taken the position that certainly as of now, agreements with non-supervisory employees that require confidentiality are prohibited, and violations of the NLRA, except in some very narrow exceptions. And the NLRB's general counsel, who's effectively the prosecutor and the person who decides what cases the board will litigate, she is taking the position. She hasn't yet had a chance to present this to the board for the board to ultimately decide on, but she takes the position that almost any non-compete with a non-supervisory employee violates the National Labor Relations Act as well. There are several new state laws that have imposed further limits. You might have seen in the news just over the last couple of days that New York Governor Hochul has had a piece of legislation on her desk that would effectively ban non-competes in New York, except for maybe some narrow exceptions. She hasn't issued a decision yet about whether she's going to sign that legislation. She's made a couple of comments about possibly inserting basically a cap on we're not going to have non-competes for people who earn less than this amount, but there could be a development soon in New York. Right now, we're recommending that employers take a few different steps to prepare for and to address these developments in non-compete law. So it's prudent, as we said, to review for no poach agreements. Those raise maybe more red flags than anything in this area. It's also a good idea when you're conversing with and you're dealing with your business leaders, with your decision makers internally who might not be quite as familiar with the status of the law, that you start exercising opportunities to reset expectations. Some people have the incorrect view that an organization could just use a non-compete to deter mobility just because we don't want people to leave. And that's never been the case. So you could have a non-compete for that reason. But if you do have non-competes for that reason now, then the vulnerability is especially high. Make sure that if you do use non-competes, first of all, that you've vetted, that you're confident that they would comply with applicable law in the jurisdiction at issue, and generally try to use the most narrowly tailored approach you can. Another situation that's going to significantly increase the risk of liabilities where an organization uses them for broad groups of workers. There are a lot of ways where you can replace a non-compete with a non-disclosure agreement, especially if you take some recommended steps for facilitating enforcement rather than just having a confidentiality provision without allowing you to take certain types of actions that can help you ensure that that's actually being followed. Consider some new compensation structures. We've been advising clients regularly about ways that you can shift comp, both salary and incentive comp, in a way that can help promote retention. And also consider consulting with a knowledgeable professional about ways that you can otherwise improve your information security so that even without a non-compete, especially if this FTC rule comes into effect, or if you're in a state that is going to prohibit non-competes, that you can still exercise other ways to prevent your proprietary information from being used against you. I want to talk briefly about one notable case in the context of the federal anti-kickback statute. So as many of you probably know, there's a federal statute that prohibits health providers from making referrals in return for remuneration. There's some prior authority that interpreted that term remuneration in a way that extended it beyond simple monetary payments. But there was a notable case recently in the Sixth Circuit, which includes Ohio, Michigan, Kentucky, and we and it provides some significant guidance for us about what a healthcare system can do and where the potential line is for arrangements with third parties. So in this case, there was a hospital that had acquired and entered into an agreement with an outside health services provider, and they provided referrals back and forth. In fact, the provider had a former employee who resigned and sought a job at the hospital. The hospital declined to hire them. The employee brought a claim asserting that the hospital declined to hire that former employee because they wanted to reward the third-party provider for making referrals. And basically, according to the employee, by the hospital not hiring them, that rewarded the outside provider because it would deter other employees from leaving the provider. It would help the provider retain key employees and basically send a message to the provider's people. The Sixth Circuit, as well as the district court, held that even if that were the case, that would not constitute a violation of the anti-kickback statute. That would not be considered remuneration. And the employee petitioned the Supreme Court to review those decisions. The Supreme Court denied a writ of certiorari. So ultimately, in the Sixth Circuit right now, that type of practice would not constitute remuneration. And that's just a signal that, at least in this jurisdiction, at least in this circuit, courts might be interpreting that term a little bit more narrowly. It's notable because there also have been some cases from outside the Sixth Circuit that have interpreted that term a little bit more narrowly, or interpreted health providers' obligations under the statute in a little bit more of a narrow way. But at the same time, there's also some inconsistency between federal circuits. So this is an area to continue to watch. There have been myriad different instances where leave and accommodation obligations have triggered for health providers, especially since the start of the pandemic. And there have been some cases and some changes recently that provided some notable guidance. A few key takeaways from COVID era claims, as Carmen mentioned, we're starting to see court decisions that rule on employers' decisions as you were dealing with all the moving parts during the pandemic. With respect to accommodations from vaccine requirements, generally, employers ultimately have fared fairly poorly in terms of cases where they have declined to provide accommodations to vaccine requirements. It's just, as many of you appreciated, it's difficult to reject an accommodation that's requested for a disability or sincerely held religious belief, because it just can be difficult to refute the assertion of an employee or a doctor, especially if they articulate it in an adequate way, that a certain sincerely held religious belief or a certain medical condition makes it either impractical or prevents an employee from safely receiving a vaccine. In the cases where employers did prevail, it typically was because the employee did not sufficiently tie either a medical condition or a sincerely held religious belief to a vaccine, to their request to not get a vaccine. For example, there were a couple cases where employees said, my religion precludes me from being vaccinated, but they didn't explain why. Or they would just make general statements about the vaccine research, and maybe some isolated cases being supported by stem cell research, and but they didn't actually connect that to any sincerely held religious belief. But if, especially if the pandemic continues, and we're seeing right now that COVID rates are increasing at least a little bit, it's an area to continue to watch and make sure that you're involving a knowledgeable professional if you do decline to provide an accommodation. Another notable change with respect to religious accommodations is, as many of you may have seen, the Supreme Court issued a key decision in Groff versus DeJoy, where historically the standard for declining to grant a religious accommodation was lower for an employer than for disability accommodations or also for pregnancy accommodations. Historically, an employer didn't need to grant a religious accommodation if that would create more than a de minimis burden, at least according to most federal courts and state courts. The Supreme Court effectively changed the standard in Groff versus DeJoy, and now the standard for declining to grant a religious accommodation is the same as the standard for a disability accommodation under the ADA. It would need to create an undue hardship. Now, typically the circumstances where a person might need a religious accommodation are a little bit narrower than the circumstances where they might need a disability accommodation or a pregnancy accommodation. But this very well could increase the rate at which people request religious accommodations, as well as making it more challenging for an employer if that religious accommodation would create a burden. I imagine many of you appreciate how it can be difficult to prove that something would create an undue hardship. That's usually a fact determination that courts are reluctant to rule upon. In the interest of time, I'll talk about maybe my favorite case in this area before I pass it back to Carmen, which provided some useful guidance for service animals. The Sixth Circuit issued a decision that appears to be the first case where a federal circuit court ruled on service animal use in the healthcare space. There was a nurse who, a nurse intern who had requested to bring a service dog named Pistol to work, and in fact bring Pistol with her as she was making her rounds. The hospital made a serious effort to accommodate her. They allowed her to bring Pistol on her rounds one day, but Pistol even triggered allergies for patients who weren't even within close physical proximity to Pistol. The hospital offered some alternate accommodations, such as by allowing the nurse intern to bring Pistol and just keep Pistol in a crate in a particular room, but take additional breaks to visit Pistol. The nurse intern declined that alternate accommodation, and ultimately she did not receive any accommodation because she declined the alternative accommodation that was offered. The court ultimately held in the hospital's favor. And two key takeaways for employers that are dealing with these types of requests, or really any request for an accommodation. Number one, the fact that the employer offered an alternative accommodation and engaged in the interactive process, had several back and forth discussions, made a good faith effort to assess what they could practically do, that went a long way. And that often is your best route if you're presented with a request for an accommodation that appears to be pretty difficult or challenging to grant. It's much better to try to find an alternative than to try to invoke the undue hardship exception generally. And then also in this particular area with respect to service animals, the Sixth Circuit relied heavily on some very good and very detailed guidance from the U.S. Department of Justice that talks about the use of service animals in healthcare facilities. So if you find yourself facing this type of situation, you want to get a starting point, consider looking for that DOJ guidance. And if you send an email, we'd be happy to put you in touch with further information on this subject. All right, I will turn it back over to Carmen for our last segment regarding remote working.
Thanks, Will. And I think you carried a lot of water on the accommodation issue because that is a subject around remote working. So thank you for that discussion of the case with our friend Pistol. This is an issue. Bringing people back to work is something that every employer is faced with or challenged with right now. The issue is, when do we bring them back, and how do we bring people back to the office? I think the when is pretty clear, like now, yesterday. A lot of employers want employees back in the workplace, but how do we do it? So we know that there can be obviously many benefits to remote working, but I think employers, especially in some industries like healthcare, for example, are starting to see that it can create some problems in a lot of circumstances to continue with pandemic era approaches to remote working. It just isn't feasible or sustainable forever. So there's some tangibles, some intangibles actually, that come with working in person that you just don't get from a remote workforce, like improving employee engagement and teamwork, efficiency, and professional development are all things that I think can suffer and have suffered in some circumstances with remote work. So there are very few statutes throughout the country that actually outright require employers to permit remote working, except as an accommodation for a disability. But I want us to focus a little bit in these last few minutes on a couple of decisions that give us a little bit of guidance. So in terms of granting remote work as an accommodation, we've seen a number of cases over the past couple of years that involve employees who are asking to work remotely as an accommodation for disability or pregnancy or some other legally protected reason. And what these cases tell us is that it's almost always relevant, the extent to which employers might have allowed remote work during the pandemic or even required it. But most courts do not consider it controlling. So just because you allowed remote working then doesn't mean you have to allow it now. Circumstances may have changed. One recent New York case sort of calls this out, and it involves a radiologist, of all things, can you believe, who asked to work remotely full-time as a disability accommodation for ulcers. So the United States District Court for the Southern District of New York denied summary judgment to the employer, relying largely on the fact that the employer had allowed other radiologists to work remotely part-time during the pandemic, and the fact that the radiologist offered to pay for part of the cost of setting up the remote working equipment. So that's one case where, summary judgment was not a given in that case. And that case went on to proceed to trial. If you're interested in the citation, you can ask for it and we can make sure we get it to you after the presentation. But in another recent case in Missouri, a hospital prevailed on a claim brought by an employee who had requested to work remotely full-time due to his multiple sclerosis. In that case, the hospital didn't grant the exact accommodation, just like what Will was saying. You don't have to give them exactly what they asked for, but if you can flex a little bit and assess a situation sort of on a case-by-case basis, that's what this hospital did in this case. They basically said, look, we're not going to let you work from home all the time because of your MS, but we'll look at the situation on a case-by-case basis when you have a flare-up, and we'll make a determination at that time. So the takeaway is that even if you broadly permitted or even required remote work during the pandemic, it's not a guarantee that you have to continue to do that. So keep in mind different ways that you can flex, but instead of jumping straight to undue hardship, which is, you're never going to get summary judgment on that basis, it's very difficult to, think about other ways to accommodate or offer alternatives that are going to get you across the bridge of actually engaging in the interactive process, and at the same time, having everybody leave the table with something that they can live with, even if it's not exactly what the employee wants, which is to stay home in their raggedy pajamas and sweatpants all day. We got to get people back. So one of the ways that you can do that is by offering some incentives. relaxing dress codes, hard incentives like increased pay or bonuses for returning to work, gradually implement return to office procedures. Don't have, work from home okay on Friday, but starting Monday, everybody's in 9 to 5, Monday through Friday. I would recommend a gradual change in circumstances to accommodate what really is a big change over the last few years. I realize that we're out of time. I am so happy to follow up with any of you who are interested, who want to reach out in the chat or by email to answer other questions, but I do want to be respectful of the time and what you've all been waiting for, which is for those of you who require CLE credits, please note the following states are approved CLE for 1 hour. So if you're in Arizona, California, Connecticut, Florida, New Jersey, New York, and Ohio, you will get your CLE credit. Just make sure to take down that code HEU 1206. You're going to receive a uniform certificate of attendance from my good friend, Robin Halligan. So make sure that you look out for that. Thank you all for taking the time to join us. Please follow up with us offline if you have other questions. We'd be happy to help. Our emails and phone numbers are on the slide. Thank you so much, everybody.
Thanks, everyone. Thank you, Carmen.